Thank you, President. I rise to move motion 155. Medicinal cannabis patients experience stigma and discrimination unlike other patients. They don't choose to be sick. They don't choose to have a serious illness or a medical condition, and they didn't choose which medication would be most effective at addressing their symptoms. But because that medication has cannabis in its name, they are all too often judged and prejudiced as illicit drug users. We have shone a light on this stigma as it applies to medicinal cannabis in the context of our driving laws, but that is but one part of the issue that we are confronting. So today I highlight another way that Victorian laws and practices prejudice medicinal cannabis patients, and I ask for this House's support in finding a solution. Medicinal cannabis is a legitimate and lawful prescription medication for people suffering from a range of serious illnesses and conditions, whether that is severe muscle spasms or severe pain resulting from multiple sclerosis, severe seizures resulting from epileptic conditions, endometriosis, or many other debilitating health conditions. Medicinal cannabis prescribed by a doctor and taken in accordance with that prescription should be treated in the same way as any other prescription medication. Unfortunately, this has not been the case with driving, and it is not the case in the workplace, which is why we want to do something about it. Some industries, like mining and transport, have legislative requirements to test for illicit drugs. Other sectors require illicit drug testing as part of occupational health and safety programs or as part of enterprise bargaining agreements. It isn't a part of every workplace, but it does cross multiple sectors and it affects many, many working Victorians. In that regard, I'd like to just note that the resolution that is before the House has been discussed and endorsed by the Victorian Trades Hall Council and the Building Industry Group in particular. For medicinal cannabis patients, this situation can have profoundly deleterious consequences. Patients, simply for taking their prescribed medication, are being caught up by workplace illicit drug testing regimes and then treated in the workplace as if they had tested positive for illicit drugs, when they haven't. It is unfair, it is discriminatory, and it is costing people their jobs and their livelihoods. Where a medicinal cannabis patient is not impaired by their medication at work, the medication they are prescribed should not be a bar to gainful employment. But in the workplace, patients are being treated as criminals because their medicine is triggering a workplace illicit drug test. Worse still, we have heard from many Victorian medicinal cannabis consumers that they have faced discrimination or dismissal when they have simply advised their employer that they have been prescribed medicinal cannabis. This is outrageous. For a medicinal cannabis patient, a positive test result is neither evidence of illicit use or of impairment. And as a matter of fairness, it should not cost someone their livelihood. Medicinal cannabis patients prescribed a CBD-based medication, which is not psychoactive, will never be impaired by that medication, but trace amounts of THC in that medication can trigger a positive test result. For these patients, there should be no ramifications from a positive workplace test ever, but that is not the case. Most patients prescribed a THC or psychoactive-based medication will not be impaired 4 hours after consumption, and most often a script of this type will specify evening dosing. So, for example, 12 hours after consumption, when a THC prescribed patient arrives at work, they will be well, truly safe at work, and with a significant buffer built in. Unfortunately, reality though is that for medicinal cannabis patients, It is that the way this medication is metabolised in the body is such that it is detectable for days and weeks after impairment has ceased. A positive test in this context is not evidence of impairment. It is not evidence of occupational health and safety risk, and it shouldn't be treated as such. Now, I know from the many, many thoughtful contributions that came from both sides of this place during the debate on medicinal cannabis driving, that this conundrum of presence of a drug versus impairment is well known to the members of this House. And can I say on behalf of Legalised Cannabis Victoria, we are profoundly grateful to the very thoughtful contributions that were made by parties from all parts of this House in that debate. So we today ask that the Legal and Social Issues Committee be tasked to inquire into this issue and to suggest some solutions. No one should be impaired at work, okay? I don't think we've got an argument there. And equally, those who are appropriately medicated and safe to attend work should not be punished for taking the very medication that in many cases makes it possible for them to be at work and to feel like functioning and contributing members of their community and their workplace. So we ask the committee, in exploring this issue, to find this balance, to look for genuine solutions that both allow for medicinal cannabis patients to live lives to their full potential without compromising the safety and health of those they work with. Thank you.